Or
Number 8, Your Honor, we, again, believe there's a rule that applies to this, and we will disclose statements that relate to the case made to these individuals and from these individuals, and we'll comply with the rule. It sort of moves into number 9 as well. Number 9 also incorporates, however, some work product, communications between counsel working on a case. So as for 8, I think the court can grant it with the understanding that it will cover our obligations under Rule 9, as will motion number 9, with the added caveat that some of it's simply work product.
right. As regards number 8, Mr. Nelson, if you are agreeing to it, what is your understanding of what you're agreeing to?
Your Honor, that's exactly what we were talking about, and I would note that the state, to my knowledge, has been complying with the Rule 9 requirements. I'm sorry, I should stand.
Actually, why don't you sit but pull the microphone closer to you?
Sorry, just the glare through here too is kind of difficult. So, Your Honor, with respect to number 8 and number 9, I understand that the state has an obligation to provide us with substantive statements that witnesses provide. I would note that it appears that the state has been doing that through various BCA reports that I've received. So I'm in agreement with how Mr. Frank articulated his obligations under Rule 9.
Okay.
Motion 9 as well?
Correct.
All right.
Your Honor, motion 10, we had a discussion about this, and Mr. Nelson indicated to me that this motion is intended to deal with situations where the court makes rulings about certain pieces of evidence or testimony, and that we would then make sure our witnesses comply with the court's order. I don't think to this point we have anything like that yet, but with that understanding of the motion, we would agree that we would instruct witnesses with regard to the court's rulings on any permissible testimony or other evidence.
All right. Defense agrees?
Yes, Your Honor.
All right.
Number 11, Your Honor, and number 12, well, I'm sorry, number 11, which is similar to state's motions 9 and 10 regarding commenting on witnesses who are not called. I do think that's covered by Rule 9 for both parties as well. So obviously we don't have any opposition to this. It is inappropriate to comment on the failure to call a witness.
And number 12 is to prohibit any counsel really from, it says the state, but I assume you join in, no counsel may express a personal belief or opinion as to the credibility of a witness.
Correct, Your Honor. I think there's a lot of case law on this, mostly directed at prosecutors, because defendants appeal and prosecutors don't. But it is inappropriate for any counsel to express a personal belief, I think so-and-so is credible. Counsel are obviously allowed to argue credibility by reference to the evidence. It's that assertion of personal belief that's not permitted clearly by the case law.
It's because they can, both sides can say this witness is not credible because of X, Y, and Z. Maybe I'm just restating what you said, but you can't say I believe or anything like that.
I think that's exactly right. Both counsel can say this person is not credible and here's why with reference to the evidence. What's prohibited is saying I think this witness is credible. And where attorneys get in trouble and go wrong is the old I submit this, and then it kind of bleeds into that. But as this motion is written, we agree. Personal opinion is not permitted from either counsel.
Okay. All right. Number 13?
13 is somewhat the same, Your Honor. And so with the same argument, I would agree with what's stated in 13.
All right. That's granted without objection. Is that?
Yeah, 14 is about witnesses expressing an opinion on guilt or innocence. It's generally improper for a witness to say I believe somebody is guilty or I believe somebody is not guilty. A witness. Obviously, witnesses are allowed to express opinions, particularly expert opinions, on ultimate issues. So we understand this motion to be directed at simply the question of guilt or innocence and prohibiting testimony from witnesses about guilt or innocence.
I think the motions include discussion of manner of death as well as cause of death. And we can get into that. That's not what you're concerned about here, Mr. Nelson?
No, Your Honor. No, what we're talking about here is there are certain witnesses in this case who, whether it be in their statements to law enforcement or in their meetings with prosecutors, have expressed opinions about, guilt and or innocence, mainly guilt from the state's witnesses, and saying, he clearly did this. This is why I think he did this, and this is why I think he is guilty.
All right. I think we're on the same page on this.
Right, but to that extent, there will be experts who will testify that this was not trained, this is not a proper use of force. Those are expert opinions.
Certainly.
That may indirectly relate to guilt, but they are not expressions of guilt or innocence. Does that make sense?
It does. And that's what I assumed that you were talking about when you said it gets close to the ultimate issue, but not the ultimate issue. I think we all understand the limits there. If we get into a gray area, just for everyone, ask for a sidebar and run it past the court, and I'll give you a ruling before it's blurted out by someone. And I think that would mostly probably be if Mr. Nelson or the state, depending on who's expert, if you object and ask for a sidebar, I'll know you're talking, well, this seems to violate the court's ruling, and I, on occasion, have directed the examining party to lead so that we get past certain prejudicial statements that the witness might make. So I encourage you to seek the court's guidance on how a question can go if we are close to the line.
I mean, this very discussion we're having shows the problem with a sort of a vague.
Exactly.
It certainly tips us off to the issue, but there needs to be a contemporaneous objection and discussion about it with particular pieces of evidence.
Well, I appreciate kind of the heads up, because if I see it coming, I am more likely to be prepared to rule, and hopefully appropriately. All right, next.
Motion 15, Your Honor, is really about disclosure. I believe we've been complying with the rules on that and would continue to do so. Obviously, we have both sides have an ongoing duty of disclosure, and we will continue to comply with that.
All right. Anything to add, Mr. Nelson?
No, Your Honor.
All right. Next.
Your Honor, motion 16 we've already dealt with regard to the first motion. Motion 17, with reference to a Washington County case. I have told Mr. Nelson that we do not intend to introduce anything in our case in chief directly on that. It would be only subject to opening the door or something happening at trial that would otherwise make that potentially admissible.
Perhaps a Rule 608 issue, is that what you say? Okay, and I'm not limiting you to that, but that was my guess.
Yeah, I mean, there are circumstances where it could come up, but our agreement today is, as in our case in chief, we would not put that in.
All right, thank you. Number 18?
Your Honor, I'm going to ask the court to skip around now a little bit.
Okay.
Proceeding to number 20, Your Honor.
All right.
I asked counsel for clarification of this, and it's our understanding that this motion is specifically directed at additional work that had been done by doctors hired by the family that have not been part of the criminal investigation. And we are agreeing that we are not going to put those in our case in chief. So with that understanding of the limitation of motion 20, particularly specifically Doctors Baden and Wilson, we would agree to this motion.
They were not on your witness list, is that correct?
Correct.
Right.
Then with the court's indulgence, I would skip over to number 24. Your Honor, this is a motion that is really kind of aimed at making sure we're all talking about the same discovery, I think, and with expected testimony. We certainly intend to have further communication about what exactly we intend to admit in this regard, and we think that will take care of a lot of this motion is aimed at. So we're asking the court to reserve ruling on this. If we are not able to work it out, I think council can renew it, but I suspect we will be able to work that out.
All right. That is reserved. Right?
Motion 27, Your Honor. At this stage, we are not anticipating putting in our case in chief any evidence about that matter. Again, it may be something that could come up during trial, could be raised or the door opened to that case through other witnesses or other testimony.
Okay.
So at this point, we're not opposing that motion as phrased, with the understanding that that could change depending upon how the trial proceeds.
And then we can proceed with either a sidebar or other conference outside the hearing of the jury on that. Anything to add to that, Mr. Nelson?
No, Your Honor.
Thank you.
Your Honor, motion 28 has a number of subsets. And with regard to paragraph A, we are not opposed to providing a list of our actual trial witnesses prior to trial. I think we talked when we discussed, maybe the week before trial. We understand, Your Honor, in talking with counsel, that a lot of the concern here is about subpoenas and getting witnesses here. And we understand counsel's concern, and they understand ours, and I think we will be able to address those concerns. If the court wants to issue something specific about this, we would suggest the Friday before that Monday. I suspect we'll have ongoing conversations with counsel about that.
Is-
We had agreed a week before.
A week before? Yes, if we could do that.
So let's assume March 29th that we are having openings and witnesses. So you're saying by March 22nd, the defense will be provided a witness, list of witnesses, the subset that you intend to actually call. Keeping in mind, you're not bound to it. It's more the professional courtesy of, here's who we're actually going to call, so you know how to prepare.
Correct.
Because how many, I think we counted,
362 potential witnesses on the state's witness list, Your Honor.
and I think all told with yours, I think it ended up being roughly 400 once you get rid of duplicates. So that would be greatly appreciated by all. So March 22nd, I think, assuming there are no other delays in the case.
Paragraph B, Your Honor, we understand that, in a sense, we're required to do this for the court's purposes of security in the courthouse as well. I don't see a problem with doing this. With both paragraph A and B, we just ask the understanding that we not be held to exactly what we've provided, because as we all know, things change, witnesses become unavailable, one day, and we just want to make sure this is not binding, that everybody understands that, and I think we do.
If you in good faith give me a list and defense counsel a list, it's basically so they know what's coming the next day. The sheriff knows who's coming the next day. If you end up not calling because somebody calls in sick that they can't make it that day, I'm not going to hold that against you. It's a problem if you want to add somebody onto the list who is not on the list. So if anything, I would shoot a little long each day so that the sheriff's office can make sure they let people in, because that's being fairly tightly controlled. And I think I made it clear that I'm not gonna, or I'm gonna try in managing the trial to not have witnesses go over more than one day, to go overnight, that they complete their testimony within one day. Accordingly, I'm asking counsel's flexibility to possibly go till 5, maybe a little later. My usual practice is 4:30 to stop, but I think given that, I think the need to get the witnesses on and off and gone prevails over getting done by 4:30. So just a heads up on that.
Thank you, Your Honor. Paragraph C, we've discussed with counsel. We certainly would not stand in the way of the defense of subpoenaing witnesses. We have some witnesses subpoenaed. We will, but we do think it's best that the defense serve a separate subpoena on some individuals who may be harder to get subpoenas served on. It's just, I think, important that both sides have that grip on witnesses. We may have subpoenaed people that we may not call, and we don't want to be the steward of the defense's control through the court's subpoena of a witness. We don't say that to be difficult or obstructionist in any way, but we just think that needs to be done by each party. We certainly will not call off subpoenaed witnesses until they can be subpoenaed if possible, to try and facilitate that process if we can. I just don't think it's a requirement of us, but we certainly will.
Mr. Nelson, is there anybody specific at this point who the state has subpoenaed, who you would also want to be under subpoena, but because they perhaps they're antagonistic to your side,
So
you expect might not show up or evade service of your subpoena?
So we have had, may I take this off?
You can, yeah.
Thank you, Your Honor. This is an issue that obviously we've had some discussion about. What I am in agreement with is, as far as any of the police officer witnesses, whether it be from the Minneapolis Police Department, the Bureau of Criminal Apprehension agents, or laboratory analysts, if those are people that are very easy to subpoena and would be cooperative with the subpoenas. The problem comes when you have a nearly 400-person witness list where there's no indication as to who's actually to be intended to call, is the expense and the frustration of attempting to serve subpoenas upon citizens. So yes, Your Honor, we have had substantial discussions about one witness in particular, who the state has already subpoenaed, and the state has indicated that they will keep that person under subpoena. I have made efforts to attempt to locate this individual, and there may be some corollary issues relating to this issue, or to this particular witness, that we'll need to address at a later date. But that person in particular. Other than that, Your Honor, by my estimation, of the approximately 350 to 400 witnesses, there are somewhere between 43 and 100 witnesses who saw some, all, or nothing of this incident. And there are certain people that are antagonistic to us. And so I think it goes to once we have the list of who the state intends to actually call, I will be able to specifically say, have you subpoenaed this person? This is the court's order. It's not, it's not Mr. Frank or the state of Minnesota's order. This is a court order. And so I'm just asking, and I believe the state has agreed not to release citizens from these witnesses until we have had the time to look at who they actually intend to call.
I think we can start with the list you provide by March 22nd of actual witnesses. Those are people under subpoena. Don't release them under any circumstance until the court gives express permission. As to the others, if there's somebody you're not on your list, I think it's important that you tell the defense whether you have them under subpoena and whether they want you to keep them under subpoena. Is that fair? So essentially that's you, Mr. Nelson, saying, what about these people?
Agreed.
I've got everybody you're going to call, but what about these people? And then you work out the subpoena nature of it.
Correct.
And obviously, I would like the defense to have their own subpoena if possible. They are all court orders. They are all equal. Some witnesses view some more equal than others. But So I think basically you just got to talk after March 22nd to make sure the people that everybody wants to remain under subpoena remain under subpoena.
And I have told Mr. Frank in prior discussions that I would give him a list of those citizen witnesses so he could compare to see if he had them under subpoena. Addresses have changed, people have moved, you know.
Well, it does beg the question I forgot to ask. Are you planning on giving Mr. Frank a list of the witnesses you intend to call on by March 22nd?
Yes, I think that's I think that's a completely reasonable two-way street.
All right.
Obviously, this does relate back to paragraph A, that list that we were talking about.
Right.
That's the quintessential problem, or you know, we're trying to address there through this. The problem, of course, with subpoenas, they are court orders, but we have the power to tell people that you're now released from that.
True.
Also in that subpoena is contact information for somebody working on our team. So then you've got a witness who is contacting our office for direction on what to do.
Understood.
And then we're in the position saying, so far, hang in there. You know, that's the sort of awkward position we get in. My understanding is there are certain witnesses that we should not release until Mr. Nelson can get service done. I understand that.
And I think basically, if they're on his actual, these are the likely ones off of my witness list I'm going to call, but you aren't, but you have them subpoenaed, I don't think you should release your subpoena. Perhaps advise them that they're released from your subpoena, but they're still under court order to appear for possibly for the defense, and that they should call, and then Mr. Nelson can give you the contact for whoever is handling witness matters in his office.
I think the most important thing is to get a different subpoena served on
Be
in everybody's
appropriate,
interest.
But I just don't want to lose track of somebody because the state didn't need them and dropped them and they disappear from the face of the earth.
Now, Your Honor, I'm standing here telling the court that we will do the best we can.
And I know you will.
Uh,
I know you will.
And I can't be a personal guarantor that this will be pulled off perfectly because, you know, they will be calling in, they will be talking, but we will do our best
Understood.
to get this accomplished.
Thank you.
We don't want the court involved in this kind of matter again, I guess I would candidly admit. Paragraph D, Your Honor, I think is really related to motion 24, which we have already addressed and asked the court to reserve. We'll deal with that.
I'll reserve.
And same thing with regard to paragraph E. And Your Honor, if I may skip to paragraph 30 or motion 30. Your Honor, we would agree that specifically as worded, the court could grant this with respect to the, shall we say, parties identified specifically in that motion.
I have to ask, how did this even become a motion? How did this become a possible answer at trial?
I think, Your Honor, one of our witnesses mentioned something like this. We do not, in context, Your Honor, I don't really want to go into.
Fair enough.
It was not inappropriate the way it was brought out because, of course, this case can be about asphyxiation. Hanging is a form of asphyxiation. There will be testimony in this case about asphyxiation. One such proper testimony about that.
Right.
Drawing a comparison to this particular person, we do not intend to do. Does that make sense?
You can prepare your witness by telling them that analogy absolutely will not come anywhere close to being admitted.
Really understood, Your Honor.
Under Rule 403.
Yep.
All right. It sounds like the state's agreeable in that. So.
Skipping, if I may, Your Honor, then to motion 34. Your Honor, I probably should actually let Mr. Nelson speak to this. I think this Spriegel incident was brought before the court before the court made a ruling. I think there has been some additional discovery since then that the defense would like to bring to the court's attention through an offer of proof. I I think I'd probably best if I let Mr. Nelson speak for himself on this
Okay.
one.
Why don't you swap places just for a little bit? Get the,
I won't read your notes, don't worry. Yeah. 34, Your Honor, is just our request to make an offer of proof. The court previously dealt with, obviously, the 404B motions that we brought relevant to the May of 2019 arrest of Mr. Floyd. The court, in its order, it issued sort of a summary order and had indicated that a memorandum would be filed by the court stating the reasons why certain 404Bs were admitted and others were rejected. We've just not received that order. What I expect, however, Your Honor, is that there has been significant developments in this regard, at least with respect to the defense perspective, that we would like to supplement our record, ultimately ask for reconsideration of based upon that new information. That was not available at the time that we brought that motion.
all right. Why don't you go ahead and do that now?
Sure. So, Your Honor, and again, I'm simply, I am speculating as to the court's rationale as to why the previous arrest of Mr. Floyd was denied. However, my speculation is that the court considered our analysis, our statement of facts to be somewhat speculative as to whether or not Mr. Floyd had drugs in his mouth at the time of his arrest. Since the court issued its order, the defense discovered and went and inspected Squad 320 of the Minneapolis Police Department. In reviewing photographs of Squad 320, there appeared to be white substances throughout the back seat of the squad car. So myself and some of the other defendants' attorneys and our investigators went to inspect Squad 320. It was very apparent that what was in Squad 320 was controlled substances. The state of Minnesota then subsequently had those substances taken out of the squad car and tested. They are, in fact, methamphetamine and fentanyl, and they contain the DNA of George Floyd. So they are partially chewed up pills. In addition, Your Honor, the additional evidence that was discovered, the state executed a second search warrant on the Mercedes-Benz that was being driven by Mr. Floyd, and located in the center console of the Mercedes-Benz were two pills that were identical to the two pills that, or appeared to be identical to the pills that were in Squad 320. Those pills were analyzed, and those pills also contained methamphetamine and fentanyl. So ultimately, if we look at this particular incident, in what the state argued was speculative, that our screenshots that we had submitted to the court in connection with that 404B, was it gum, was it something else, was it drugs? I think the question has been answered, that we now know for a fact that there were drugs that were in the car. We know that there were drugs in the squad car that contained Mr. Floyd's DNA, and that those drugs in both of those cars were identical to the drugs that were in Mr. Floyd's system at the time of autopsy. So in that regard, Your Honor, if we liken it and we go back to what happened in May of 2019, when Mr. Floyd was pulled over, put a large amount of drugs in his mouth, he was taken into a squad car. He was then ultimately hospitalized, where he had to be physically restrained by hospital staff. And so it would be our intention to provide the court with all of those additional records, just simply as a supplemental offer of proof in that regard.
And you can make that offer of proof by filing those, but the question I have for you, and this is so you don't have to speculate as the court's ruling, what 404B exception does all this go to? What does it establish that is an element of the crime here?
Well, it establishes a modus operandi, essentially, of Mr. Floyd, and when Mr. Floyd is apprehended, or at least in one prior incident, when he was arrested by the Minneapolis Police Department, he did the exact same thing that he did here. And when we get into the question of his cause of death, is he actively ingesting narcotics that would potentially cause his death?
Well, does it really go to that, though? And I'm asking this, you know the file better. It could have been. I don't think the state's contesting the fact that fentanyl and methamphetamine were found in Mr. Floyd's blood after his death. Is that correct, Mr. Frank? And the amounts, I think, are what Dr. Baker is going to talk about. Why does it matter that he took it in response to police action, that is the police coming up to his car, versus maybe 15 minutes before or an hour before?
Sure.
The bottom line is, they're drugs, they're in his system, unless you're claiming, or the state's claiming that someone involuntarily intoxicated him by essentially forcing drugs on. I don't see how it establishes.
Because, Your Honor, and perhaps this is the missing component, because ultimately what is being said a lot about this particular case is that the Minneapolis police overreacted to a $20 counterfeit bill. But what people in our line of work, whether it be the court, the defense, police, the state, we understand that these are fluid situations that often evolve. Maybe an initial very minor report, but when the police go to intervene and suddenly you learn that there are drugs in the car or guns in the car, I'm not suggesting there were guns in the car here, because there weren't. I'm using this as a general example. Or there are warrants for someone's arrest. These are evolving situations that call into question the amount of force that police are authorized to use. And so it's a lot different if you're trying to conceal or secrete controlled substances than it is, a $20 bill. This isn't just a $20 bill. And it ultimately goes to the very nature of the police response.
Well, and as I understood it at our September motion hearing, there is not an assertion by the defense that Mr. Chauvin knew or had arrested Mr. Floyd as part of that May 16th, 2019 incident.
Correct. But if you look at the 2019 response, right? The Minneapolis police pull him over. The officer draws his firearm immediately because Mr. Floyd is not showing his hands. And I know that in this particular case, Officer Lane did that exact same thing. It goes to the measure of the police response to that particular situation. So if we're going to come in here and we're going to have experts from Los Angeles and Montana and wherever else they're coming in from to say this was an unauthorized use of force, and you have a prior incident where officers used an identical use of force in an almost identical situation, that's where it becomes relevant.
Well, you can make your offer of proof. We can revisit it later, but I'll be honest, I'm not convinced. I could see where that evidence might be proper if you had said Mr. Chauvin was part of that arrest or knew about that arrest, and therefore when he had the contact with Mr. Floyd that resulted in his death, I could see where it'd be like, oh, this is what he does. I have knowledge that this is how George Floyd reacts to police interaction. But it doesn't establish that because Mr. Chauvin wasn't a part of that arrest.
Understood, Your Honor.
It's more of a generic, let's pick a situation because we have the body-worn camera and Mr. Floyd on it. There could be other body-worn cameras that show that that's not how the police react to it. So I guess I'm telling you right now, I'm not convinced yet to reverse my ruling, but I'll consider whatever you have as far as written offer proof.
Thank you, Judge.
All right, thank you, Mr. Nelson. Mr. Frank.
All right, we'll only briefly address that. I want to correct a couple of just factual errors if I can. The SUV contained 2 white pills that had distinctive markings, were unchewed, undigested, laying loosely in the center console area that contained methamphetamine and fentanyl. There was a pill fragment, a couple of pill fragments found in the back of the squad car that only contained methamphetamine. So I don't think we can say that those pills are exactly the same, first of all. In the prior incident, Mr. Floyd did not have to be physically restrained. He was treated by medical professionals when he admitted to using some pills on that prior occasion in 2019. He got medical attention at that incident. So some factual things I wanted to address, but
And Matt, I'm sorry, I want to check that second test of those pills.
okay,
Sounds like we have a discovery issue you can deal with later.
we have a second test. I don't know.
Well, the bottom line is, it's not of consequence to me. I don't see, even if there are the similarities described by Mr. Nelson, that it is a modus operandi which is relevant, that establishes, that goes to any of the elements in this case. There's no prior relationship that it establishes or knowledge by Mr. Chauvin. Any minor probative value it has is certainly outweighed by its prejudicial nature.
Pure propensity, Your Honor. I guess.
Which is
I agree
why
with you.
I suppressed most of the states for the same reason, that it goes to propensity. Any case. Next, Mr. Frank.
So then, Your Honor, motion 35, we would ask the court to reserve this. I had asked counsel to try and narrow this down to specific records, specific items. I think we'll work on that. So I think we would simply ask the court to reserve motion 35.
Okay.
And then, Your Honor, motion 37. I don't know, I have no personal knowledge of what the National Prosecutors College is. I don't believe we have had any contact with them or sought any information from them. If it's, we have the rules of discovery that we have to disclose statements that relate to the case. And I think that, well, quite frankly, I think the court should just deny this.
What organization are you talking about, Mr. Nelson? I know that the National Advocacy Center used to be down in South Carolina, but that's been closed, so I'm not sure what organization we're talking about.
So it's my understanding that I've heard from other prosecutors that it's an organization that gathers materials relevant to expert witnesses and their testimony, copies of transcripts, things of this nature.
So you think that they might have collected something about your experts?
If they have, or even their own experts, that would be, I think, discoverable under the rules.
I agree, if they have collected them. Mr. Frank?
Whether it's this organization or a similar organization.
Mr. Frank?
To my knowledge, Your Honor, we have not obtained anything from this organization that counsel might be referring to. I'm not sure that if we did, it has to be disclosed. It would simply depend on what it is.
Well, I'm going to tell you, if you got it, you're going to disclose it. Whether it's from a prosecutor's organization or somewhere else where you've obtained transcripts, basically, because I'm familiar with the concept of the transcript banks. A transcript that could be used to cross-examine your expert or their expert, for that matter. Sometimes I know prosecutors will get it for their own to know what's out there that they have to defend against. So if you have it, he gets it. It's not work product.
It's not work product, Your Honor, but it may not be a statement relating to the case.
Well, that may make it not admissible, but I think this is a discovery issue.
So if an expert says something on the witness stand
Correct.
right? That raises a question based on something they've said before, written before. It doesn't become a statement about the case until they testify.
Correct.
In terms of having to disclose it. So not.
No, I think it is, we're talking discovery here, not admissibility. You may disclose it, and none of it's admissible, because there's nothing in it. For example, if they give opinion A on the stand, and there's a transcript, in another case they said not A, that's permissible impeachment of their opinion, to go in and say, well, in State versus Smith, didn't you say X, Y, and Z, and now you're saying A, B, C. I think that's permissible impeachment. And if you have transcripts, I think discovery-wise, Mr. Nelson's entitled to them.
But what I'm saying is, until that witness says not A on the witness stand, that prior doesn't, I may be mixing up the court's analogy. Until that witness says A on the witness stand, not A isn't a statement about the case.
Correct.
It's potential impeachment.
Correct.
So there's no duty to disclose that until he says not, until he says A.
I'm telling you to disclose it.
And then I assume the court will be telling the defense to do that as well.
Absolutely. If you have transcripts of somebody's, the other side's witnesses or your own, those should be disclosed. This is in federal court where you have to wait till cross-examination.
Your Honor, that is all of the defendant's motions we were prepared to address today. There are several of our motions that we could address. I don't know if the court wants me to
Well,
yield the podium or start in on those.
Is there, can we talk about number 33, the Spark of Life, or did you want to wait for later?
I would prefer to wait, Your Honor.
That's fine.
I mean, Spark of Life is a very familiar topic to us all. I'm hesitant to start into it today because I'm not sure what the contours that defense counsel is thinking of with regard to Spark of Life testimony. To me, it's pretty straightforward, but I'm just not sure I know exactly what the problem is there. So we did not talk about it ahead of time, and
All right, why don't the two of you talk and we can address it later.
yeah.
Okay. All right.
So it's my understanding that the other defense motions that have not been addressed today, we will address tomorrow or as scheduled.
Subsequent days, correct.
Okay. Do you want me to start on ours, or do you want to?
Mr. Nelson, are you prepared to?
On the states, yes, I'm
Yeah,
not.
all right. And if you could reference, I will assume on the state's motions that these are from the motions filed February 8th, 2021, unless you tell me otherwise.
That's my, that's what I'm working from, Your Honor.
All right, and these are also numbered, so if we can walk through the numbers, and let's start with things that are not contested that you've essentially agreed on.
I actually think that the vast majority of these will not be contested, Your Honor.
Okay.
With respect to witness number one, or excuse me, motion number one, we have no objection as to the permissible grounds for impeachment. Would not use a FBI report or a BCA report to impeach a witness who didn't prepare that statement. Number two is one that is going to be contested. It also corresponds to a subsequent filing that I don't have pulled up right now. But number two will be contested.
I think that you're talking about the state's second amended.
Correct.
That were filed on March 4th. Is that correct, Mr. Frank?
It is, Your Honor.
These-
Amended motion 2.
Understood. Thank you. Mr. Nelson.
Thank you. Motion number three, Your Honor, I think is premature. I think that goes to the questions of jury instructions. Obviously would not make any reference to any rules of law that were not contained within jury instructions. But because we have not had a jury instruction conference yet, I think it's premature.
Mr. Frank, would you agree with that? And I actually need a microphone by you.
the problem I have with waiting, of course, is we will have voir dire, we will have jury, we will have opening statements and witness testimony that could depend on what these concepts are and what they're going to be. So I don't think this is something we can reserve until the end of trial when we're looking at the final jury instructions. Because as part of our motion is, any testimony or argument about essentially incorrect standards of law. So I do think we need to address this certainly before opening statements.
Well, again, my strong position is nobody should be trying to instruct the jury on the law, because that's my job at the end of the case. And so if counsel starts to ask jurors their opinions about what does this charge mean, and use words like but for or intend, that's going to be problematic in jury selection, just to warn you. But Mr. Nelson, do you object to these, or what part do you object to?
No, I don't necessarily object to them, Your Honor. I just think that in terms of what the appropriate legal standards are, we have not thought about those, for lack of a better term. And so in that regard, Your Honor, it's not my customary practice to inquire as to the law or the rules of law in voir dire. And I rarely ever reference any sort of elements in an opening statement. So, it wouldn't be my intention to do this, number one. So if the court wants to grant it subject to a jury instruction conference later, that's fine too.
I think that's the best way to handle it. I'm going to grant it subject to the jury instruction conference, because I assume the state is relying on the substantial factor in causing death.
Correct. And we did submit a memorandum that addresses this motion too.
And I think everyone is in a safe harbor if you rely on the jury instruction guides for elements, generally. And so if these aren't in the jury instruction guides, you are in dangerous waters. So I'll grant it with the understanding that we'll talk about it at our jury instruction conference.
Sounds good, Your Honor. Number 4, I'm just asking that we address that later in the week.
Okay.
Number 5, I think is very similar to the one of our jury instructions. I have no objection to that, Your Honor.
Okay, that's granted without objection.
Number 6, I think, is also part of our ongoing discussions about the training materials that both sides intend to introduce and the reasons for which they may be introduced, whether it to show that Mr. Chauvin received particular training or the policies of the MPD. And so that's just a discussion that we're continuing to have. I think we've made some substantial progress in that regard, and so just asking to reserve it, and if we need to come back to that at a later time.
Any objection to reserving it, Mr. Frank?
No, Your Honor.
All right, that's reserved.
Number 7, I have no objection to that, Your Honor.
Okay. That's granted without objection.
8, no objection.
Granted without objection.
9 and 10 are identical, and they are also identical to one of the defense motions the court
Right.
previously
I think
granted.
we've already established that you're not going to comment on each other's failure to call a witness. And if the answer to that was to call 400 witnesses, this would not be a 4-week trial. Go ahead.
11, again, in terms of, I believe that the court has already issued its ruling on all 404B stuff, so it would be no objection to that other than subject to.
Re-arguing the May 16th.
Yep. Number 12. Again, I have generally no objection to this. However, the state has agreed to provide me with the criminal convictions of witnesses, and if there is any intent to use any prior criminal convictions, we can cross that bridge should we learn of any.
Thank you. I'll essentially reserve that.
Okay. And I believe that's all of their motions.
Mr. Frank, anything else? You had the second supplemental, but that was basically the reserving on the expert.
Correct, just because we had obtained additional information from the time of the first motion to the second amended motion.
All right. So I didn't count them up, but we've got a handful of motions left to argue more substantively. Is that correct? I'll try and identify them myself. But that's it for today then, as far as motions?
Well, as far as motions, Your Honor, just other than stipulations as to strikes for cause.
Yeah, who wants to, somebody wants to take the podium and...
Your Honor, for the record, again, over the mid-morning and early afternoon break, counsel for the defense and state met and conferred and reviewed agreed upon jury strikes. We are in agreement to strike juror numbers 5 for cause, juror number 11 for cause, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. We only made it through the first 50, Your Honor.
No, that's fine. That helps us a lot as far as who to call in. Let me make sure I've got it correctly. 5, 11, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. Is that correct? State agree?
That's correct, Your Honor.
All right. Based on the stipulation, we'll release those people for cause. Since I think the parties are obviously being very thoughtful about the proper use of our time in jury selection by identifying these ahead of time, I may reduce the number of jurors we bring in from 16 to possibly 12 or 14. The last trial we did in here in January, which was a murder in the first degree case, we were pretty good at keeping 6 per session, 6 in the morning, 6 in the afternoon, and getting to everybody. So I'm thinking this one we might be able to get, there might still be cause challenges that will be granted. So my thoughts are 7 and 7. But if you have any advice to the court on that, I'm happy to hear from anybody. So, but I think for now we'll go with 7 and 7. All right. Is there anything else for the record today? You can't do it. All right. Anything further, Mr. Nelson?
No, Your Honor.
All right. We are in recess. Tomorrow, the jury has been ordered to report at 8:30. And so we'll try and get started with jury selection by 9 if we have motions at 8. So we will come back at 8. The jury is expected to start with selection at 9. And I'll start that with the basic group discussion or instructions before we go one by one. As I've said to the state, unless the Court of Appeals tells me otherwise, we're going to keep moving. So with that, we're adjourned until 8 a.m. tomorrow. Thank you all.
cable though. That's a defense counsel did, so I'm assuming they'll take care of it.
Craig?
Yep.
So do I just leave this here so they can charge it?
Yep. I'll come and pick it up because I'm gonna put them all on the charger for the night. How's the face? How can you tell? How's the audio coming across from
Really
the?
well.
So you think it's just this speaker?
I thought I was surprised how soft it was from my perspective, Dana. So I'm glad it's.
So, because I'm like, this is really soft, and like I said, there's nothing.
Yeah. So I'm glad it's coming across on their feed, but I'm gonna call Andy to come up and see if they can adjust that because I thought it was pretty soft.
Okay,
So
it's really,
there could
Who's
there,
audio?
there could be jurors, back, especially Dana behind
so
that